When there are some problems in the family and you receive a notification letter from the court, what do you need to know when you go to court? Welcome to the defendant or opposite party in the family law cases section. Let us answer your questions. Before you file a complaint, matters such as marriage, parentage, guardianship declarations, death pronouncements, inheritance proceedings, and domestic violence incidents are subject to mediation or adjudication by the family court within the judicial system. In order to provide equal and rational dialogue opportunities for the parties involved in family law cases, the court, with the exception of specific cases, generally engages in mediation before proceeding to adjudication. In family law cases involving the rights of minor children or individuals with disabilities, the court may appoint a guardian ad litem for them, serving as their legal representative in legal proceedings to safeguard their best interests. You can search for information about guardian ad litem on the Judicial UN's website. Attending court alone sounds scary. Is it permissible to have someone accompany me? If the case involves victims of domestic violence, minors, individuals under guardianship or assistance, during mediation or trial, it is permissible for a social worker or an appropriate representative to accompany them in court. I'm a foreigner and cannot speak Chinese. What should I do? Don't worry. The court provides interpretation services. If you do not understand Chinese or have hearing or speech impairments, you can fill out an application for interpretation services to the court to ensure the protection of your rights. Now, there are family cases service centers or domestic violence service offices in district courts, which provide multiple services such as escorting in court, psychological support, parenting education and counseling, legal consultation, and referrals to relevant welfare resources. You are welcome to make use of them. Your rights in mediation proceedings. In the course of the mediation proceedings, both parties can fully express their opinions. When mediating the dispute between the parties, the mediator will offer a neutral and fair perspective and jointly discuss a reasonable solution. The court will appoint an appropriate family mediator based on the nature of the case. For instance, when the case involves minor children, the court will appoint family mediators with professional backgrounds such as social work or psychological counseling. In order to enhance parental knowledge and capabilities and collectively safeguard a wholesome environment for children's growth, the court may notify parents to participate in parenting education courses or refer them to family cases service centers for counseling and guidance. If the parties cannot reach a consensus, the court cannot force or compel either party to agree. Maybe you're curious if what you've said in an unsuccessful mediation can be used in litigation. Don't worry. No proposals or compromises made in the process of an unsuccessful mediation can be used as the basis for a judgment in litigation. The judge will consider the dispute itself, so you can feel free to say what you want to during a mediation. Make sure you understand the hearing notification letter. When a court hearing is necessary for the case, you will receive a court hearing notification letter. So what parts should you pay attention to? First, you should note the contact details of the court and the clerk in charge. Once you're at the courthouse, you'll give your case number to court personnel so they can check on your case. The cause of action refers to the type of family law case it is, with the court classifying it based on the facts presented by the plaintiff or applicant. Depending on the type of family law case, it can be categorized into either family litigation proceedings or non-litigation proceedings. In legal proceedings related to family law cases, the initiating party is referred to as the plaintiff in family litigation or the applicant in family non-litigation proceedings. The other party is the defendant in family litigation or the opposite party in family non-litigation proceedings. The time of arrival indicates the time the proceedings are scheduled to begin. Note the location of the proceedings, including the courtroom number, to avoid going to the wrong place on the day of the hearing. The type of session reveals what the court is prepared to do on the court date. In family litigation proceedings, the most common procedures are preparatory proceedings and oral arguments. In family non-litigation proceedings, it typically involves an investigative procedure. The preparatory proceedings and the investigative proceedings are to confirm the claims of both parties and investigate evidence related to the case. The oral argument session is when both parties tried to persuade the judge to rule in their favor according to the results of the evidence investigation. The notes column will give details of anything you need to pay attention to during the court hearing. What should I do if I can't attend court on the designated date? You can appoint an agent. If your agent ad litem is not a lawyer, you must first be granted permission from the court, or you should provide a valid reason for your absence. If I receive a hearing notification, do I have to attend court? When you receive notification of an oral argument session from the court, if you or your agent ad litem will be absent without a valid reason and you don't dispute the claims, this is seen as you accepting the claims and facts as the plaintiff states them. The judge can then declare a judgment on the basis of the plaintiff's pleading. Be aware that your absence without a valid reason will impact your rights and interests. In the first and second instances of civil litigation, it is not compulsory to hire a lawyer, so you can represent yourself in court. However, undertaking a lawsuit requires a certain level of legal knowledge, so if you do not understand the law, you can contact the Joint Service Center at any court for help, or hire a lawyer to represent you. A lawyer will allow proceedings to go more smoothly. The parties involved in family law cases can also inquire with the staff of the city or county government's family cases service centers or domestic violence service offices about any related welfare or legal services they might need. Filing counterclaims. When you receive the court hearing notification letter, you'll also receive a copy of the plaintiff's or applicant's pleading. If you disagree with the plaintiff's or applicant's claims and wish to dispute them, you should submit counterclaims to the court within the time frame specified on the court date notification letter, or provide copies for each plaintiff or applicant before the hearing. How do I write a counterclaim pleading? You can visit our website, and our AI customer service assistant can help you. Just enter a term in the search box. You'll find templates and examples to use as a reference. Your counterclaim pleading should include 1. Facts supporting your claims. 2. Evidence to back your counterclaims. 3. Aspects of the plaintiff's or applicant's facts and evidence that you agree or disagree with. If you disagree, provide a reason. After completing your written pleading, you can mail it or submit it in person to the court. Preparing for court. The day you are set to appear in court arrives. If the court has agreed to remote proceedings, please refer to the Remote Court Proceedings Handbook in advance. For more info, you can scan the QR code in the top left corner. If you are attending court in person, remember your appearance should reflect your respect for the court. On that day, remember to bring your ROC ID card or other identification, your notification letter, and any other required documents indicated in the notification letter. If you wish to bring additional documents for the court to consider, remember to prepare extra copies for each plaintiff or applicant. Ideally, you should arrive early at the court to register, giving yourself time to find the courtroom. Please make use of public transportation when possible. Don't forget to log in a bit early if it's a remote proceeding. There are 2 ways to register your arrival at court: at the counter or the check-in kiosk. Then, wait for a court attendant to call you in. If it is not your turn yet, you can stay outside in the waiting area. If the appointed time arrives and your case hasn't been called yet, the previous case may have gone over on time. Like hospital clinics, courts hear several cases every day. So please be patient. You can check the progress of the previous case on the court's website or on the LCD monitors outside the court. After entering the courtroom, please remain silent and be respectful. Court procedures and your rights. Private recordings of sound, images, or photographs are not permitted inside the courtroom. To protect the privacy and reputation of the parties and their families, family law cases are generally not disclosed or open to the public during court hearings. There are two kinds of family court. The first is the general family court, where the judge's bench is at the front of the courtroom, below which sit the clerk and interpreter. In the center is the witness stand, with the family law cases investigation officer and guardians ad litem, positioned on the right side of the courtroom. The plaintiff or applicant and their legal representatives are on the right, while the defendant or opposite party and their legal representatives are on the left. Witnesses and related individuals await their turn in front of the spectator area. The second mode is the communicative family court, which uses a long negotiation-style type table to facilitate communication between the parties involved. In the center at the front is the judge's bench, with the clerk and interpreter positioned to the left. The family law cases investigation officer, witnesses, experts, and related individuals are located on the right. The left and right sides are divided into the plaintiff or applicant, defendant or opposite party, legal representatives, and their accompanying individuals or guardians ad litem. When proceedings begin, the judge will allow you to speak, so please be patient. When the judge asks you for an explanation, you only need to state the important points. If the judge is unclear on any parts, they will ask you to expound on them. If you're worried you can't explain things well, you can submit a supplemental written pleading. Please respect your opponent's right to defend themselves. Do not interrupt them. If you want to counter, please raise your hand. You may speak again with the judge's permission. If it is necessary, the court may appoint a family law cases investigation officer to investigate certain aspects of the case. The family law cases investigation officer is tasked with presenting a report and providing opinions in court to assist the court in understanding the true issues in family disputes. This information serves as a reference for the judge making the judgment. In principle, parties can give their own opinions on the content of the report, and the report will be used to refer parties to relevant agencies and social services for counseling or other resources, so they can obtain appropriate assistance. In court, the clerk will make a written record of the main points of the proceedings. Everyone will have a computer monitor to view this record. If you discover an error or a misunderstanding in this record, you can report it immediately. The court will organize all the information from the proceedings and bind these documents in order in a case file. It contains records of what the judges, litigants, and witnesses said in every court hearing. The litigants can apply with the court to review the case file during the proceedings, or apply for the case file on CD. After the court has undergone the necessary investigation of evidence and given both parties ample opportunity to make their case, if the judge thinks that the court has clarified everything, the required investigation, they will announce the conclusion of the oral arguments. If you have any evidence or material you wish to present to the court, you should do so before the judge announces the conclusion of oral arguments. Otherwise, in principle, you will not get another hearing in court, and the material you wish to present will not be considered. For cases that have concluded their oral arguments, the judge will subsequently announce the judgment day in court. On the judgment day, the judge will announce the judgment in court if any litigant attends. In non-litigation proceedings regarding family law cases, no specific judgment date will be announced. The judge will determine a date for delivering the ruling. Going to court is not as difficult as you might imagine, so let's protect your rights together.